Thank you for joining us. Today, we have Anna Uberman, who is a Maricopa County Justice of the Peace. She is the former presiding judge of the Justice Courts. Anna has been a Justice of the Peace for over a decade, and she does a lot of training in our community and handles Country Meadows Justice Court, which has some of the largest volumes in the county for many matters that include DUIs and evictions. So today she's going to join us and tell us a little bit about what she sees from the bench when somebody gets charged with a crime and how that affects their lives and other aspects. So we call those collateral consequences when you get charged with a crime. Hi, thank you for joining us.
Oh, thank you so much for having me.
So, the mission that we have in this podcast is for our viewers and our listeners to have information when someone gets charged with a crime. What people don't realize is the other consequences that they have. So, from the bench, you see a lot, and you've had thousands and thousands of cases. What do you see when someone gets charged, for example, with a DUI? Do they have another consequence? Do you see that, for example, in an eviction when somebody got arrested in their own apartment?
There are a number of additional consequences that could come from any type of crime. I will say that the law requires that we explain some of those consequences to defendants, but there's actually case law that says that we don't have to explain all of them. And so a lot of defendants leave the court not knowing what additional consequences they may have. And we are not obligated to tell them. I had made an effort always to learn what some of the most um, common consequences are and to let defendants know before they leave my court. But obviously, I can't know everybody's circumstances and everything that happens, so I can't always tell them everything.
Of course.
But for example, if someone has a commercial driver's license, there could be a lot of consequences from having any kind of criminal conviction, definitely from having major traffic convictions, which would include DUI, even criminal speeding or reckless driving. That could affect their license, which then in consequence affects their livelihood.
Yes, and so glad you brought that up, the commercial driver's license, because sometimes people don't realize that if they have more than one DUI, their commercial driver's license can be revoked for life. And that's a lifetime ban. And so while one DUI may have been from another state or years ago, if they get a second or a third, their livelihood, like you said, could be ruined permanently.
Right. And, all traffic offenses, moving offenses, uh, or, yeah, moving offenses, they carry points on the license. And so those points also affect people in a variety of ways. Definitely commercial driver's licenses, of course, but it could affect your insurance rate. It could affect, if you have an excessive amount of points, you can get your license suspended. So it is important that everyone understand what those consequences may be. I don't know that there's always a way to avoid those consequences.
Right.
Uh, they just come with what, if you have a DUI, they come with 8 points. And there's no way that you can really eliminate the points if you are convicted of the DUI. But what's important is to know what those consequences are, what those points are, and what they mean, and so that you can avoid those affecting you in some other way in the future.
Yes, and every single case is different, right? Um, but every time you get another DUI, the consequences could be greater, right?
So DUIs, if you have a first DUI, I guess we'll call it just a normal DUI. Those get charged as a misdemeanor, so they would come to the justice courts or to the city court. The DUIs, the law in Arizona um, has what we call minimum mandatory penalties for DUIs. So the judge has to impose at a minimum
Yeah.
the penalties that are described by law. There are situations where they could be higher penalties, but at a minimum, the DUIs carry certain fines, certain assessments, and jail time. Those are mandatory, the judge must impose. If the person gets a second DUI within 7 years of the first conviction, the second DUI may also be charged as a misdemeanor, but it does carry harsher penalties. So the fines are higher. They do carry a significant higher jail term.
Yeah.
And then usually the third DUI, if someone gets a third DUI, that is charged as a felony.
Yeah.
Which means it doesn't come to my court, that goes to the superior court. Those DUIs also carry mandatory minimum penalties.
They do.
And the minimum penalty they can get is 4 months in prison.
Yeah.
And I'm not exactly sure, but I think it's close to like $15,000 out of the monetary consequences of a felony DUI. And then any little thing could make that even worse. If you had a minor in the car with you, if you
your license was suspended, it becomes an aggravated DUI.
Right. And so some of those things could lead to an accident where someone got hurt. Those things could lead to much higher consequences and much more prison time. And then you have a felony on the record.
It's unfortunate the ramifications that it has as a ripple effect with everything. And we use DUIs as an example of a criminal charge. But another one that has a lot of consequences are charges that are deemed domestic violence offenses. Do you see those in your jurisdiction?
We see them, but I think not as much as the city courts, just because of a matter of geography. But we do get our fair amount of domestic violence cases. Those are also classified either misdemeanors or felony, depending on what the action itself was. So there could be a misdemeanor assault, and so that comes to the justice court. But if the assault broke someone's arm or did made more damage, that could be sent to the felony court directly, and that come through the misdemeanors. But just as like with DUIs, if you get a first domestic violence, the consequences could be they all carry mandatory domestic violence counseling, but it could be that the consequence is only the 26 hours of counseling.
Yeah.
A second domestic violence offense could carry jail time, but a third domestic violence offense is charged as a felony. So even if it's not as serious, it is still charged as a felony only because you've had the prior domestic violence offenses.
Yeah. And so domestic violence, it's whole other thing. So let's use it for an example of a situation that there are spouses who are having an altercation in an apartment complex, and a neighbor calls police. Police comes, there is an arrest. Suddenly that family gets an eviction notice because it's against policy that you have some criminal activity at the buildings. That's pretty much standard in Arizona. Do you see evictions in your courts? And what do you see that people go through in difficult situations, like the breadwinner was arrested, for example? and then their families who got an eviction notice?
So it can happen in two different ways. One is because a crime was committed on the property and they would get a notice of immediate eviction telling them you have to move out tomorrow.
Yeah.
Um, so that would be one of the consequences. Obviously, when I get those cases on my eviction docket, I want to be very careful that I am not evicting the victim. So if the person being evicted was on the lease, normally a tenant is responsible for the activities of everyone who's on the lease or even the guests who come to the home. So technically, if the breadwinner commits the domestic violence, whoever else lives in the home would be responsible and could be evicted.
Yeah.
But I believe that domestic violence is a particular situation where we definitely want to avoid re-victimizing the victim of domestic violence by evicting them from the property. The problem is that the second way they can end up evicted is because now they can't pay the rent.
Yeah.
Because this person has been taken to jail and is not paying the rent. And so there's nothing we can do about that when the person is being evicted because they did not pay the rent.
For lack of payment.
Arizona, you can be evicted with just 1 month of rent that you missed. And so if in the scenario that you gave, the breadwinner is hauled off to jail, can't pay the rent, then the other persons living in the home, whether it be the victim and their children,
Yeah.
can be evicted.
And how much time do people have if they did not pay rent?
So when you don't pay the rent, the landlord has to give you a notice, giving you time to pay the rent that you owe. They have to give you 5 days to pay.
Okay.
And then if you don't pay within the 5 days, then they can
Move forward
with the eviction case. But eviction cases work very quickly in Arizona, and you could be in front of a judge within a week.
Oh, wow.
So it really doesn't give you much time. The shortest timeline between the non-payment of rent, the notice, and the filing of the case,
And
the service of the case, and the hearing could be 17 days. Someone could miss
Very
1
fast.
month of rent and be out, ordered out, let's say today, the 17th, and then the writ of restitution, which is the order that the judge would sign for the constable to remove the person from the home, would issue 5 days after that, so on the 23rd. So missing 1 month of rent, you could be out on the street with less than a month.
Wow. Wow, that's very fast. I didn't realize it was that fast. And that's with the due process.
That is with the due process, yes.
Yeah, that's very fast. Do you also see petitions for orders of protection in your division?
We do. We see a lot of petitions for orders of protection.
And the orders of protection or injunctions against harassment. When somebody, again, let's go back to a similar scenario. If there is an alleged victim that comes to get an order of protection against a spouse, and they're both living in an apartment, and the petitioner writes the home address, which is the apartment, the other person is not able to return, right?
Correct.
And so if that person that is the alleged perpetrator, the defendant, is the breadwinner, we're in the same circumstance, right?
Right. So with the petitions for order of protection, we can order what we call exclusive use of the home. Because obviously if you're giving an order that this person needs to stay away from this other person, they can't live together. And so the person who gets the order gets the exclusive use of the home. That doesn't mean that they are getting anything except for just the use of the home.
Mm-hmm.
So if the perpetrator is the owner of the home and the victim is just there by invitation,
Yeah.
that would resolve legally in a different forum, not through the order of protection. But at the time of the order, that person is allowed to stay in the home.
I get calls from clients all the time who they are the homeowners. The girlfriend is in the home. Now, the girlfriend alleged domestic violence. The client is still paying for the mortgage, but he's not allowed to live in the home. And the orders of protection can be up to 2 years, correct?
Correct.
So now he's paying for the mortgage. He cannot use the house. He has to pay taxes, utilities, HOA, everything that he has to pay. And then on top of that, find a place to live.
Right, but that is why we call it exclusive use of the home. That does not entitle the girlfriend necessarily to be able to stay in the home in perpetuity or for the 2 years or for whatever amount of time it is. So that person can ask for a hearing for the order of protection and have the exclusive use removed. That is more difficult because the judge obviously doesn't want them both in the same home. But I would assume that they could file an eviction or some other sort of action by which they are allowed to obtain the possession of the home. That the fact that an order of protection is given doesn't entitle the other person to be able to keep the home.
It happens so many times.
It does, and it's very common. It's more complicated when there's children.
Yes.
Because then if there's children in common, it really probably doesn't matter who the owner of the home is. You want to give a home to the children. But those are things for the family court to resolve. We do not get involved in any of that.
So it's possible for somebody who has an order of protection issued against them to have the hearing in your court. Also, they may start an eviction process. And at the same time, if they have children, have a family law matter in family court in Maricopa County, right?
Correct.
So sometimes one incident can spread across multiple areas.
Correct. I mean, the consequences can't always be that easy to discern what they're going to be in each case because each case has its own particular set of circumstances.
Yeah. Yeah.
What I do want to add, if I may,
Yeah, of course,
is that the Arizona Landlord-Tenant Act does have a provision for domestic violence.
Okay.
Which allows that the person who has been the victim of domestic violence can terminate the lease without penalty. And this is done for several reasons.
Okay.
One could be because they cannot pay the rent on their own, so they won't be able to stay there, so they can leave before they get evicted. The other is because maybe they don't want the perpetrator to know where they live. And so that would give them the ability to be able to move addresses
Safely without information.
Right. So those are the two reasons that the Landlord-Tenant Act does allow them to terminate the lease without penalty. Obviously, the rent has to be paid up to the date where they terminate it. It has to be within the month that the order of protection or the police report was filed. They need to provide a copy of that to the landlords. In general, I have seen that the landlords are willing to respect that part of the law, and they do allow the persons who have been victims of domestic violence to terminate their lease.
That's so important to share because a lot of people go through that. And sometimes people who end up getting charged with the crime, they're sometimes the spouses who have suffered abuse, who have suffered at the hands of another person. So the request, and thank you for sharing that because I think sometimes people forget of all the options that they have. So when somebody wants to terminate their lease because there is a domestic violence situation, do they need to do that through the courts or do they go to the management do they go to the management company's office or do they contact their landlord or do they go to your court?
No, they don't do that through the court. I, as a habit, always explain this option every time I issue an order of protection because a lot of people don't know this. Um, and but then they have to do that directly with their landlord, whether it's through the management company or however their internal um, administration works, but it's not done through the court.
And so I don't know if you know this, but do they need proof? So, for example, a victim of domestic violence, do they have to have a police report to go to their leasing office or an order of protection, or can they go and just express their own situation to the leasing agency?
The Landlord Tenant Act requires that they present either a police report or an order of protection, one of the two.
Okay.
Um, they that does not require any additional proof. It doesn't require that the perpetrator has been convicted of the domestic violence. It doesn't require anything more than just showing that they were issued that order of protection or that they made a police report as to the domestic violence.
Yeah, and I think sometimes that's a tough one because, well, I don't know if I'm quoting this statistic correctly, but the average person takes about 7 tries to leave an abusive relationship. So whether that is uh, trying to leave physically or plan the exit, it takes about 7 tries. And domestic violence, as you've probably seen in your courtroom, comes in so many colors, right? It could be emotional abuse, it could be physical. Usually, we're always looking for bruises for the obvious things, but financial abuse is another one. In another lifetime, I was a counselor of victims of domestic violence and sexual abuse, and it really opened my eyes to see how people were suffering, because it's not clear cut. And something that I didn't expect, and I was young back then and naive, is how um, immigration was used sometimes as a power struggle and to abuse other individuals. I remember having a client who was in her late 70s who had been here in the United States since she was in her early 20s when she married her husband, and he had never fixed her papers.
Mm.
So, over 50 years of marriage, and he was very abusive. And as a counselor in the community centers, we try to help them. And, but obviously, we were not attorneys back then, and I've not done immigration law since the graduation. I graduated. So, sometimes immigration comes into play in a lot of these scenarios that we've been talking about. So, eviction, for example, right? What if somebody, and I don't know if this scenario has come up since these new ICE raids. Um, if somebody, for example, is renting and ICE comes to arrest a person within the apartment and they're taken, but the rest of the family stays behind, does that fall into the arrest of an individual within the home that would trigger an eviction?
Well, you just hit on the most difficult thing that we see in evictions, which is what I explained before when you have an immediate eviction and everyone is responsible for the acts of everyone else.
Mhm.
And what does that constitute as a criminal act? Is the fact that the police came to your home the fact of a criminal act? Is the what if they came and they got the wrong person?
Yeah.
What if they came and they were executing a warrant that came from another county? What if, I mean, we see these cases and they are sometimes very hard to decide.
Yeah.
Um, I think it depends a lot on who the landlord is and how strict and how far they want to take the matter as to are they going to make the other tenants in the home pay because ICE came to the home to take this person. The same token, if it's the police that came because they were executing a warrant, or the idea is that you can't commit crimes on the property.
Mm-hmm.
So when someone comes to get you, just because you're on the property, are you committing a crime?
Right.
There's just, I mean, I would suggest that there's probably not all the judges see it the way I do, but it is a complicated topic.
And these must be difficult decisions for you and other justice of the peace to make on a daily basis.
They are, and they're very heart wrenching, a lot of them. So in this case, in your scenario, for example, I would anticipate that the attorney would argue that the other tenant knew that that person was in the country undocumented, and they should have understood that that was a possibility that could happen. And so that they would be responsible for that person being taken. I mean, it's an argument.
Yeah.
Um, those are the type of arguments that we hear most of the time. I haven't had any case directly that's with ICE. I'm not saying it's not going to happen, but
Right.
I haven't had one yet when they've come to the home.
Yes.
But those are the arguments that I would anticipate.
Yes. And being a justice of the peace comes with a lot of responsibility. And you were the presiding judge for the justice of the peaces here in Arizona in Maricopa County, right?
I was, yes.
Yes. And you are the immediate past presiding judge because your term ended in June, right? And so, as a justice of the peace, when people are, it's an elected official, right? A position where people get voted. There is no requirement to have an understanding of the law, but you have an advantage. So you have parents. You were born here in the United States, but parents who are also from Argentina. And eventually you went back and then you went to college and you have a law degree.
I do, yes.
And so that gives you a greater understanding of the law.
It does. It makes it easier to understand the law, even though it's not the law that I studied in Argentina. But I think it also gives you that legal mind to be able to reason things legally, and to walk through. Not everybody can know all the laws all the time. So you just have to be able to read it, interpret it, and make decisions based on it. So I think that even if I have a degree from a different country, it has served me just as well as anyone who has a law degree from the United States.
Yeah, I agree. I agree. You can do a legal analysis in a way that other people are not able to do. But that's not your only exposure to the law because you were in Maricopa County Superior Court for a very long time as a court interpreter.
15 years, yes.
As a court interpreter.
Yeah.
And so you were in the courtrooms every day.
I was, and I got to listen to all sorts of cases, all sorts of arguments, all sorts of legal analysis. I wasn't allowed to make any decisions on any of
Right.
that, but I did absorb. And I think because I had that law degree, I was able to absorb a lot of that information and process it. And that was an incredible learning experience as well.
And for justice of the peace who are elected and they don't have a legal background, there is a training, right?
Yes. Yes. The Supreme Court requires a 3-week intensive training program for new judges. But Maricopa County, internally, we do our own process of training, which is much more extensive, much more in depth than what a classroom can offer. We pair new judges with mentor judges who sit with them for months.
Oh, wow.
So that's been the objective of Maricopa County for the longest time. Um, to make sure that all of our judges are well prepared and are able to take the bench, uh, and make decisions, because we do make decisions, as you said, that affect people's lives. I mean, sometimes it seems, oh, it's just a speeding ticket. It doesn't seem like a big deal. But again, if that person has a commercial driver's license, or that person had points, or technically could have immigration consequences. There was lots of consequences that could come from even these, what would seem like not serious cases.
Yeah, and I am familiar with the training here in Maricopa County for judges. It's extensive and it's very well developed. So incoming justice of the peace will have background before they get on the bench on the laws with domestic violence, evictions, DUIs, and even things as a simple assault, right?
Yes, all sorts of all the case types that we do, and we do a lot of training on dealing with self-represented litigants, dealing with people who come to court that don't have an attorney, who don't know how to defend themselves.
I
Um,
think that's a very important point. And if you can tell us a little bit about the difficulties that people experience, because sometimes people underestimate what a misdemeanor trial or their own representation would be.
it is. A lot of people think that they can come to court, that they'll be able to defend themselves, and then when the time comes, they are at a loss. They're not prepared. They don't know how to ask questions. They don't know what the focus of their defense should be. Um, but there's also a lot of technicalities. People think that we know everything that they're going to tell us.
Mhm.
That I mean, this morning I had a person who told me, "Well, the landlord has that document. Did they give it to you?" And they just assumed that because it is a document that the landlord had, that they had an obligation to give it to me and that I had seen it. And so it's those kinds of things that make it very difficult, because then comes the time for trial or for whatever it is, and they didn't bring the witness, they didn't bring the documents, they don't have everything that they need to prepare a defense. It is very, they don't know what to ask for.
And as a judge, can you excuse somebody who is not doing well because they're not attorneys, or do you have to follow the law as it is and look at the elements of a crime, for example, if they presented their defense or not?
So I do need to follow the law. I need to find, but for criminal cases, whether the defendant puts on a defense or not, in the end, it is the state's burden to prove the crime. And so I would never hold it against the defendant who did not present evidence, who was inartful in their presentation, who presented the wrong evidence, because the decision is going to be made based on the state's evidence. For other types of cases, it gets a little more iffy, but defendants, there's actually been a recent change to the Code of Judicial Conduct to give the judges a little more leeway in dealing with self-represented litigants. Uh, you can't give legal advice. You cannot suggest defenses. But if someone needs to lay foundation
Mm-hmm.
and the other party objects, like, foundation, you can explain.
What that means.
This is what foundation means. Can you explain who took the picture, when it was taken? Those kinds of things, that you can do, but we can prompt them. You've presented a bunch of documents here. Do you want any of those to be admitted into the file? Little things like that. Uh, but everybody needs to be on equal footing. It's true that sometimes the attorneys forget to
Yes.
move to have a document admitted, and I will also ask them.
Yes.
So we don't give priority to one another, but we do want to make it an equal playing field, and expecting the self-represented litigant to be able to do everything as if they were attorney does not equal the playing field. That actually makes it more difficult.
Yeah. That has to be difficult to see and then to decide where you're going to lean when as a judge and as a person you see another individual struggling with that. But unfortunately, I do see it when people call my office after they have represented themselves. And so at that point, if they lost at trial, we would have to appeal, and appeals are very costly. It's different. The appeals are charged hourly, which is different than a criminal representation, which is a flat fee. So that ensures that there is not crazy amount of hours billed is a set amount and there's no more there. So appeals become financially difficult for people to do. I see those with orders of protection. People call those all the time. I didn't know. Well, I didn't know that if I went and it's not true that I'm abusing my child. But those allegations are very powerful because even if they do a hearing in your court or any other court, everything that they share at those hearings can be used against them. And so when people are representing themselves, they can put themselves in danger by making statements or trying to explain the situation. Sometimes people say, well, I didn't do this, but I did this other thing. And so I see it frequently. And unfortunately, appeals are cost prohibitive sometimes for people.
And appeals is one of those areas where there's much less leeway for the self-represented litigants.
Yeah.
If they miss a deadline, if they did not include what needed to be included in the brief, whatever, there's really no remedy for that.
Yeah.
The judges are the Court of Appeals in general is very strict as to what things need to be included, and if they're not included, there's nothing they can do to overcome that. So I agree that, trying to do appeal on your own is very difficult. We've had some cases where self-represented litigants are successful in appeal. Mostly is because they had a good topic to appeal.
Yeah.
And it probably didn't matter how well they articulated it in their brief. But it is, people think that they can appeal just because they don't agree.
Yes.
And that is not what appeal is. An appeal, you have to show where the error that the judge committed was. So they interpreted the law incorrectly, or they applied the wrong law, or they misunderstood the evidence, or something very specific. Not, most of the appeals are, I didn't do it, the judge shouldn't have convicted me.
And I think you bring up a very important point because as a judge, you have to weigh and balance. Right? Let's talk about a criminal case, aggravating factors and mitigating factors. And then you give your decision. And at the sentencing, people sometimes don't like what they receive as a sentence. Is that enough for post-conviction relief or for an appeal?
Not necessarily. It's not because you don't like it. There has to be a proven error, something that they could point to get the appeal to be able to be, or the conviction to be overturned. I think the bigger problem with people who self-represent, and in general, maybe even people that have attorneys, is that a lot of these matters are very emotional.
Yes.
And so it is very hard to separate the emotion from the actual facts. I've had people take cases to trial because they didn't like the way the police officer treated them. And they wanted the trial just so they could come and tell me how bad that police officer treated them.
They feel wronged.
They feel wronged. And so they'll be, well, maybe I was speeding, but he had no reason to pull me out of the car, or he had no reason to
yell at me. Yeah.
Whatever it was. Um, and it's very difficult because they're ending up going to trial on a case that maybe they could have resolved in a different way because they have that emotional that's just making them want to be able to come and talk about their case. That happens with orders of protection as well.
Yeah.
People just have that need to be able to say what they want to say. If you request a hearing on order of protection, for example, you become a prohibited possessor. You cannot have weapons.
Yeah.
And so then they'll come with like, well, but I did my weapon. I'm like, you shouldn't have asked for the hearing then.
Mm-hmm.
But they wanted to ask for the hearing because they have that emotional need. And so these are very difficult decisions for anyone to make without the advice of an attorney. But unfortunately, our system does not allow for most of these cases to be assigned attorneys.
Yes. Can you explain to that? Because sometimes people get upset about not qualifying. Who qualifies to get a court-appointed attorney for a misdemeanor?
So in justice courts, and then there is also case law as to this. Only persons that are facing jail time are entitled to have an attorney. So that would be any person who has a DUI, because there's a mandatory jail term as part of any DUI. So they are eligible to have an attorney appointed, but then they have to also qualify financially for the court to appoint an attorney.
Can you break that down? What does that mean?
So one thing is the right to have an attorney, and the other one is the right to have the court appoint you an attorney that you're not paying for. If you are asking to be appointed an attorney and not pay for that attorney, you need to show that your financial situation is such that you cannot pay for an attorney.
So is that based on the income level?
It is based on income level, yes. Years ago, we simplified the forms that we use in the justice court. We used to have a 3-page form. It's impossible for people to fill out.
Yeah.
Uh, Maybe it could be filled out by someone who does make $500,000 a year
Yeah.
and can understand all those categories. We have simplified the form. It's a 1-page form. It asks for your marital status, who you live with, how many people do you support, what is your take-home pay,
Yeah.
and what is your monthly expenses. There's some other categories. Do you owe outstanding loans, or do you receive money for child support? But there's basically just those categories, and they're very simple to fill out. And based on the income level and how many people they support, then the judge can find that we call it indigent, that they cannot pay for their own representation, and they would appoint them a court-appointed attorney.
So what happens if they qualify because they're looking at jail time and they also qualify financially and they get an attorney and they don't like the attorney?
So the law allows you to have a court-appointed attorney, not to choose your court-appointed attorney. If there is a significant breakdown in communication, they would come and talk to the judge, and the judge could figure out maybe what's going on. A lot of times, they just don't like the advice the attorney is giving them.
Yeah.
They complain because the attorney says, this plea is better than if you go to trial, or, they don't agree with that. That doesn't mean it's bad representation. But if there is a significant problem, maybe we could appoint another attorney, but usually it's not
That's rare.
very rare. You don't get to decide.
Yeah. Yeah. And every attorney works differently, right? Like, do you see everybody doing the same quality of work? Maybe I shouldn't ask the question. Maybe I shouldn't ask that question.
Yeah, maybe not.
Okay. All right.
I can tell you that our public defenders are very dedicated public servants.
Yes.
And that they do a good job.
Okay.
And I see a lot of private attorneys that do very good jobs as well.
Yeah. Okay. I shouldn't have asked that question. Yeah. One last thing before we end, because we have collateral consequences outside of the judicial system also when somebody gets an order of protection, for example. Sometimes orders of protection allege crimes against children. So, do you see in your division requests for orders of protection where there is an allegation of abuse or sexual abuse against a minor?
I have seen those.
And typically, when those get served and then law enforcement gets involved, DCS gets triggered as well. So DCS, for those of you who are not aware, is the Department of Child Safety. And so it used to be called CPS before, Child Protective Services. And that is the organization that focuses on investigating allegations of crimes against children. So that's a ramification outside. And also background checks.
So, I mean, one of the things that surprised me the most is that having a DUI conviction can affect a lot of people in different ways, but not necessarily all jobs are going to have an issue with a background check with a DUI. Don't count on it.
Right.
But the one that will always get you, though, is theft.
Ah.
A conviction for theft, that you will never be able to get a job working in a bank,
Yeah.
working in retail. You may not be able to rent a home because your background check shows that you had a theft.
And sometimes that theft could be something so little of maybe small shoplifting that somebody does when they're young adults, maybe 18, 19.
Right. I mean, I have a couple of thefts that people haven't paid restitution. They've been around my court for years. One of them has $7 of restitution.
Yeah.
So there are a lot of them are very small amounts, but when it goes on your record, it's still a theft.
So what happens when somebody doesn't pay for restitution? Does that go on their credit?
Restitution, we cannot close the case with pending restitution. So we issue warrants for their arrest.
Oh my goodness.
And they get arrested, and we can't give them credit for jail time because what they owe is restitution to a particular victim. And so they get released from jail.
And they still have to pay.
And they still have to pay, so they don't pay, and then they get another. We do order to show cause first before we send people with warrants, giving them an opportunity to come to court, explain why they didn't comply. But yes, people get warrants for not paying restitution.
And sometimes people don't want to pay for restitution. I have clients that say, I'm not going to pay for that. That's a touchy subject.
It is. I mean, if I may tell a little story, when I first moved back to the United States, we had an old car that was worth nothing.
Yeah.
And it got stolen. And I guess the defendant was told that if he paid restitution and did whatever, that it would get dismissed from his record.
Ah.
And one day we get this check for whatever it was, the blue book value of the car, $300 or whatever it was. And that was money that I never expected to get.
Yeah.
But the defendant did pay restitution because it did help them get this off the record. And so, that happened to me 30 years ago.
Yeah.
But I always have that present.
Yes.
When I impose restitution, so people understand that once you pay it off, it liberates you and it gives you a bunch more opportunities than what you would have if you just ignored it.
Yeah. It's in here in Arizona, we have misdemeanor compromise. And not a lot of people use it. A lot of people understand it. And it's not a way to buy your way out. But in non-domestic violence situations, you could, all the chips have to fall in place with the state, whether it's the county attorney or city, and the victim, right?
I think it's always worth considering, always worth looking into.
Yeah.
I keep a copy of the statute on my bench.
Yeah.
because I think that it shouldn't only be for people who know it existed or had an attorney to point it out to them.
Yeah, I always tell all my clients, like, let's our first stop. Let's look at the damage. What's the damage? Is it criminal damage? Was it an issue with property? Like, what's the cost? Sometimes it's a lot. Sometimes people cannot come up with the value. But I have some very successful stories where there was no intent to hurt anybody or to damage anything.
And the victim agreed.
And the victim agrees.
Right.
Yeah.
I mean, I agree. I think it's a very useful tool, and I think it's something that should be considered.
Yeah. Yeah. So, you're not able to give legal advice to anyone.
No.
So, we can't give legal advice to our listeners, but I think that the knowledge and information that you've shared today is very valuable for people who are, whether they're in Maricopa County or not, but here in Arizona, and they find themselves with a case represented by an attorney, whether it's court appointed or private, or themselves in situations to keep in mind everything else, right? How one
To ask questions. Ask questions.
Yeah.
I think that it's one of the people just tend to accept the information they're given and don't question it.
Yes.
I see that in evictions all the time. I was told, they told me that. Did you get it in writing? No, I didn't. Well, I think that's part of the issue is, to question and to ask. And if you're self-represented, if you don't have an attorney, advocate for yourself.
Yes. Thank you so much for your time.
I have one more thing I wanted to add.
Yes,
if I could. You can place it in wherever you want. So in Arizona,
Yes.
we have the ability to set aside convictions and seal records.
Yes.
This is something that actually has expanded over the years.
Yes, it has.
And it is an incredible resource for defendants who have criminal records. I am always surprised that a lot of people don't come to get their records sealed. For many of your listeners, they might call it expungement.
Yeah.
We don't call it expungement because that's not the terminology we use in Arizona.
Right.
But in the end, it is the same effect as expunging your record, sealing the record, getting it taken off your record, whatever you want to call it. But this is an ability that anyone with any type of crime, whether it be a felony, a misdemeanor, everybody has that ability to do it. Misdemeanors, you need to wait 2 years if it's a class 2 or 3 misdemeanor.
And their fines and fees have to be paid.
Everything has to be complied with.
Yeah.
But if everything is, but you have a theft that we talked about that has so much consequences.
Yeah.
Afterwards, you can get that theft sealed after 3 years.
Yes.
And if your restitution obviously has been paid. But then when you go apply for a job, when you go apply for an apartment, that will not show on your record. This is giving you a second chance. We even give them certificates of second chance. So that is something that I think everyone should definitely be aware of. I tell all my defendants when they come, everybody today carries a smartphone.
Yes.
And you can put something in your calendar for 3 years from now.
Yes.
Put it in your calendar so you're reminded 3 years from now to come and request the sealing of the records.
Thank you so much for reminding us of that. It is very important. We do hundreds of those for clients. But I think justice courts have forms that they can fill out, right?
We do. Yes, they just have to come to the counter or get them online. They're very simple. They walk through it. They're very easy. All of our forms of justice courts are very consumer oriented, yes. And they just have to go down the form and fill out the information.
But it's not guaranteed, right?
It is not guaranteed, but the state would have to have a reason why they're opposing it. The victim, if there's a victim, would be given input, and if they have a reason to oppose it. But if it is in the interest of justice, the judge will seal those records.
Perfect. What a nice note to end on. Thank you so much, and thank you for your time
All
today.
right. Thank you. Thanks for having me.
Thank you. Dun, dun.
How long was that?
Almost an hour.
Oh, huh.
Mm-hmm.
That's what you wanted.